Good afternoon. Welcome to the Creative Finance Collective. I'm Andy Fowler, and we have with us Sean St. Clair, Drew Jenkins, and it looks like we got Scott Horne with us. How you guys doing?
Doing good.
Yeah,
Doing well, can't complain.
yeah. So if you're joining us for the first time, the Creative Finance Collective is an opportunity for us as attorneys to talk about all things creative finance, but what we are here for is to answer questions that you, the listener and viewer, might have. So we'll be on here up to an hour or until the questions stop or until we get sick of each other. One of the two will happen sooner
Is it
unless
that
they
time yet, Andy?
what's that?
Is it that time to be sick of each other yet?
It's getting close. We're on the cusp. Um, but we'll take questions for as long as you have them. So make sure to post those as you go. Also, if you're watching us on a platform that is not YouTube, there is a barcode at the top of the screen that you can scan with your phone, takes you to the YouTube page, which gives you really the best place to view the content. So go there, subscribe. We'd appreciate that. What's the latest in the creative finance world? What's it looking like in Texas these days, Scott?
Slowing down is probably the better way to put that. I think, we're seeing in our own world, guys, from a marketing perspective, the acquisition side is not slowing down. The sale side to the wraparound borrower seems to be slowing down a little bit. What used to be a 30 to 45 day time frame for marketing is now closer to 90 to 120 days, we're seeing. Unless you're in that really, really low end property size a little bit, which really doesn't exist out there. I keep seeing a lot of these, I'm gonna call them younger investors who think that just because they have someone who's willing to sell their home subject to the existing debt, that it's an automatic deal. And there's just a lack or an inability to know how to run the numbers properly. I know it's a learning thing that they had to go through, but they just want to turn these and burn these deals so fast to make that quick buck on an assignment fee. They just don't think through it. And, you wish that wasn't the case. It just takes more time to do it, but there's been such an influx of them into the marketplace so fast, that they don't know what to do or where to go. And especially when things start to slow down a little bit, it becomes a problem for them.
Interesting. Sean, have you experienced a slowdown in the last month or so? What have you seen?
So I don't get too involved in the disposition side. So we will do some work on self-performed closings for the acquisition side, and those haven't really slowed down. So that's consistent with what Scott is saying. On the disposition side, we generally don't get involved in that side too often. For a couple of reasons, and kind of jumping to the question that's going to be coming up here. Those are disposing to a consumer buyer. A subto is, not the easiest thing. It's high risk, high liability, potentially. And you have to make sure you have everything in place. And so we don't really get too involved in that because if we do, our fees are generally, somewhat cost prohibitive for that. And so, they'll self-perform or they'll go find title or do something to try to close those, maybe do an agreement for sale. Scott raised his hand. He'll do them. But speaking of that, are you in Arizona now, official? Like if I came to you and wanted to sell my house, will you be my escrow agent? Is that how this will go down, Scott?
Well, we signed leases. We move in on the 12th. I think it's the 12th. We'll be in your fair state then.
Well, not only in our fair state, I hear we're going to be neighbors.
We're going to be neighbors. Unfortunately, not down the hall.
Okay.
But the the courtyard. So same thing, only different. And it's probably a good thing because you get sick of seeing me too much, probably. So, but yes, we are up and running. In fact, we've already opened 15 or 16 files there, and we're not even open yet.
Wow.
Very cool.
I wouldn't
Very
say
cool.
that's because of me or because of my partner Susan, but it's more because of Susan. And I'm pointing across the way to her here.
Yeah.
But it's really because of the gals there in Arizona. So we're
Yeah.
coming
Well,
there.
we've been dropping your name. You know, once again, I mentioned that we do some self-performed closings, mainly, you know, FHA, VA type stuff. But you know, we're not closing attorneys. So we're doing it, but you know, now that you guys are here, you'll do FHA, right?
On acquisition or wraps, absolutely.
Yeah. Mm-hmm.
It's just title's the issue that you have with that most underwriters don't want to issue title on those.
Right. So they self-perform with no title insurance, or they get title insurance post
Yeah,
closing.
we just pull an abstract
Yeah.
and make sure it's clear, or as clear as we can get it.
Hmm.
And I'll tell you guys something. Being a title attorney for 30 years, it's kind of like being in the insurance business as well. You know, as an investor who has done and placed 7,000 plus houses, you often ask yourself, why do I have hazard insurance? Because my lender requires it, right? But then you look back historically in time, and I'll go, okay, I've dealt with maybe 4 properties that had fires of some type. We've dealt with probably 20 or 30 hail claims and things like that, and 1 car running through the front living room. Okay. But then you look back, you go, how many gazillion dollars have we spent on insurance along the way? And you go, if you could have ever self-insured, it would have been great.
Mm.
And at what point in time you might do that? You flip over to the title side of business and the abstract side, where we have closed, I don't know, 30, 40,000 transactions over 30 years in all of our various offices. And personally, I've only had 2 title claims ever that were both fraud. I mean, we'll talk about one of those in a minute. It's kind of interesting to hear it out there because you don't see that too often. But that's it. 2, and I bet you I've done 14,000, or I've paid for 14,000 title policies, whether buying or our mortgagee title policies. And I know it's a requirement. You don't have an option, but sometimes you go, wow, that's just, you wonder where money is made and how it's made. That's it.
Right.
But it's just, you look at those things, it's just interesting. And so knowing that, guys, at least here in the Texas marketplace, when 98% of the homes that the investors buy are owner occupied houses. And I'd love to hear your input about Arizona and Georgia a little bit on this. So, Texas is set up so that there's only 3 kinds of liens that can attach to a homestead. So we're dealing with 98% of the properties, homesteads, with a purchase money mortgage that can attach a properly executed mechanics lien contract, which has a very narrow lifespan unless it's a mortgage type contract, or a tax lien, be it IRS or property tax. So knowing that, you're looking for a very small amount of things, so anything else that attaches to the property can be removed, because by the Constitution, it can't attach. And so when we pull an abstract of title, it helps to narrow the focus a little bit instead of widen it. That allows us to run with it for the most part.
What about HOA liens? Do they attach?
The who?
HOA liens?
If you're in an HOA and they file a lien, yes, it will.
Oh, okay.
Because you've agreed to do that. But that's not a constitutional issue. That is where when you move into the area, you subscribe to the HOA automatically.
Correct. Yeah.
You want to live there. But it's going to be, as we know, secondary to any other, it's going to be junior to any senior mortgages that are out there along the way. So knowing those kind of things in Texas, it does help to understand how infrequent, there's ever a title issue.
Mm.
I mean, I've dealt with it twice on my own houses and probably a total of 5 or 6 times over 30 years in the title industry. Maybe we just been lucky. I don't know, but you see that, it tells you what the odds are a little bit. What do you
Your
guys
state
see in
has some
Arizona?
special
Georgia?
rules. So, all sorts of things can attach. You have water, you have sewer, you have solid waste, you have in Alabama, you have municipal liens for abatement. Apparently, maybe in Savannah, maybe the city can also lien you for weed abatement. No one knows. I just got a former buyer reached out. They did weed abatement back in December of 2022. They never told anyone, and of course the seller failed to disclose this as well. And all of a sudden they slapped a notice on the front door of the home letting her know that they're about to file a lien for the property, and they cited a provision. So I sent it to my underwriters, and my underwriters are like, or two different sets of underwriters, right? Saying, hey guys, is Savannah weird? And they're like, not to our knowledge. And apparently they're relying on like the international building code or whatever for the municipal code, but no one knows if they actually have the right to lien or not. So yeah, we have all sorts of things that we need to pay attention to, and Homestead's not going to protect you from any of it. So yeah,
Well, I will
we
agree
have
with
we have a
you.
lot more issues than
Yeah,
y'all.
I'll agree with you on municipal liens can attach, and not only do they attach, you cannot remove them. You have to pay them, just like property taxes. It's just one of those things that is not optional. It's mandatory. But I find it interesting. I bought a house, guys. This was a home. When I say it was a hoarder house, it was in absolutely disgusting condition. We find a dead dog in the bottom drawer of a dresser.
Oh,
And you kind of go, you gotta be kidding me. And it's like, how did it get in there? How did it die? And who knows? But this is a home, talking about municipal liens, that had been abandoned pretty much by the kids after mom and dad had both passed away. And it probably had $6,000 of mowing liens on it. The city, of course, had filed suit, and the penalty was $100 a day on their judgment, for every day it was out there, which means it was adding up fast. And of course, we had the deal. We hunted down the heirs. It took us a while to get everybody on the same page. And then you go talk to the city, because there's $50,000 of, the municipal lien for the mowing, which is an automatic attachment. And then it's the fines being assessed against the property. And, rarely will they negotiate mowing liens, but what's interesting is every time they remow a yard, the administrative fees here in Texas seem to increase. It may be $175 for the cost to mow the yard and administrative liens the first time. $175. It would have cost you $25 to have anybody else mow it.
What are you talking about?
Well, the
That's
next
half the
time it
price of
might
what they
be,
charge here.
yeah, $300. The next time it might be $500. The next time it might be $600 or $700. It's like, we're getting tired of this, guys. Fix the problem. We're going to keep adding more, admin liens to it every time we have to do this. So that's kind of interesting. But so many people are scared to go talk to the city. So we went and talked with the city, and of course, all they wanted was they wanted the house taken care of. They wanted the house back on their tax rolls properly. And they cut that 40-something thousand dollar, administrative fines down to, I think, $6,000 for us, which was awesome, and wound up being a great deal. But you have to go out there. If you don't ask, you don't get, right? But it's also helping the investors realize there are some things that they will do. There are some things that they won't do. Those mowing liens, they had to pay. They actually cut the admin costs down a little bit. But you had to pay for the cost of the mowing and those kind of items. They just didn't want to demolish the house and go through all the issues and the risks of those kind of things. But, when you look at those kind of issues from a title perspective, we see so often here where the municipalities, they may go out and mow a yard and create this lien. They just don't record anything for 90 days or 120 days. So of
Or
course,
2
someone
years.
bought the house 3 months earlier, and then 90 days later, they file a lien on the property, and it's like, yeah, stop, guys. You can't lien the house anymore because the prior owners don't own it anymore. One of the things we make a habit here of doing is whenever we think something's been sitting vacant for a little bit, we automatically contact the cities to see if there's anything out there, just as a fail-safe.
Right. So in Alabama, that's part of our title commitments on B1, right? It's a requirement that if you're located within a municipality, you have to contact the city clerk and determine whether or not there's any abatements or unfiled liens by the city. In Georgia, we don't generally have that issue, which is why the Savannah thing that cropped up last week is so new to us, is most of the cities apparently have not walked through all the legwork to be allowed to have these inchoate liens. Again, unlike water, sewer, solid waste, right? All these other utilities. And so that's why it's kind of a thing of first impression for the underwriters, as well as, hey, they're claiming a lien from something they did in 2022, and they still have not actually filed the lien, right? All they did was they put the notice on the front door of the house, but they're claiming a lien unfiled from an action that took place in 2022. So, I mean, even when you do everything right, you sometimes still don't do it right enough. And of course, the stupid thing is, because you're right, the first time they get out there, it's not that much, right? It's, I think in this case, like $1,100. It's a lot more than your 175.
$1,100 to mow the yard.
Yes.
Wow.
So the question is it even worth fighting, right? And so from a title company's perspective is, sure, you might be able to win it. But in our case, we didn't insure it anyway, because to us, this thing never attached to begin with. But Savannah apparently is taking the position that, oh yeah, it attached because we said it did. So it'll be interesting to see how that one plays out.
Well, things are weird in Savannah, right? Because you have the Savannah bananas down there, right?
There's all kinds of things weird about Savannah. I have a lender that I work with, and they hate Savannah and dealing with the way closings work down there. They have their own special way of operating, I guess, because they've been around longer than the state has.
So when I brought up the Savannah bananas, you know what I'm talking about, guys?
I don't.
No.
I see deers in the headlight. So it's a minor league baseball team.
Mm.
And I just highly suggest y'all Google Savannah bananas. They're hysterical. It is funny. Just wait till y'all watch it. We'll talk about it next time.
All right. I thought maybe it was going to be your new the name of your new lawn mowing company at $1,100 a lawn. Maybe we can get in on that one
maybe
together.
In another life, I'll do that.
Yeah.
That'd
Yeah.
work.
If you're just now joining us, folks, this is the Creative Finance Collective. We're taking questions and discussing creative finance. We do have a couple questions. Also, if you're just now joining us, we have a link up here at the top that will take you to the YouTube page. If you're not watching us on YouTube, that's one of the best places to watch this content and interact with us. But we do have a couple questions. So you've mentioned in the past that the disclosures in a subto disposition may be different than an acquisition. Can you explain? Sean, I know you've talked about this a number of times. Why don't you start?
Yeah. So depending on the nature of the transaction, you're always looking at, who's the party that really needs to fully understand or appreciate the transaction, right? So if it's an investor acquiring a property subject to, you're dealing generally with a consumer seller, right? A seller that doesn't really fully appreciate or understand maybe what exactly this transaction is going to look like, what the potential results are or whatnot. So from an acquisition standpoint, you want to make sure that the seller, acknowledges and understands a few things, such as, hey, look, your loans are going to remain against the property. They're still going to be on your credit. It could impact future lending. There's due on sale that could, crop up. Those types of things that you want the seller to, if it's a VA, like this could impact your entitlements and future VA financing. And you need to put that all in there and make sure that consumer seller fully appreciates the nature of the transaction. You don't really need it so much on the investor acquisition side, because hopefully if an investor is going in there negotiating this type of transaction, they fully appreciate or understand the transaction. Now, let's say that that investor is going to then assign the transaction to another buyer who may not fully appreciate the nature of the transaction, right? They just think, hey, there's a deal under contract. It looks to be seller carry. I don't need to bring much cash to the table, good interest rate, whatever. And they're going to assign it to me. I'm going to pay an assignment fee and I'm all, good to go. Well, I've seen where basically close at or, prior to the closing table, the buyer is like, what exactly am I doing? what am I buying? How am I buying it? Why am I executing this, performance note, this performance deed of trust mortgage? What is this? And they don't fully appreciate the fact that, hey, this is a subject to, which means, there's a due on sale clause, that there's some risk here, that you're coming to the table with, say, 40 grand, and you're going to make you're going to pay the assignment fee, you're going to close. And, you run the risk that a month later, the lender finds out, calls the loan due, and now you have to sell the property or do something. Right. And oh, by the way, now you have this money that you've invested. So you want to make sure that that buyer goes in with their eyes wide open. And so it's those types of disclosures, on an assignment, for example, I would say, hey, if you're going to assign a subject to, that assignment better have, some pretty good disclosures to the assignee, such as, the loans are going to remain, that there's these other lenders out there that, insurance could be an issue depending on, whether the lender will accept other insurance, or you may have to pay double for insurance if you want it insured. The lender could call the due on sale, those types of things that you want to make sure that the buyer knows. And then the same for a disposition where you close on the subject to initially, and now you are the investor owner, and then you're going to go and sell it to a third party buyer. They need to understand the nature of the transaction. They also need to understand that, hey, look, you do not, have full control over the loan, that you don't have, that there is this due on sale, that they may not receive all of the information and they're the power of attorneys and different things that are executed in a standard acquisition. It's on a disposition side, and that they have to understand there are these other loans that are out there that these lenders could call the loan due. And so you want to make sure that the buyer fully appreciates the nature of a subject to transaction and the risks associated with it, so that they know that, hey, this is what I'm getting into. This is what's going on. Here are the risks. Here's, potential exposure that I have by, doing the transaction this way.
So we have a couple follow-up questions. Some relate, some don't. We'll just work through these pretty quick. Do you need to pay a lien that isn't a judgment? So a lien against the property that isn't a lien by virtue of it being a judgment, or some sort of recorded judgment lien.
Well, I'm going to take a moment and answer that for here at least. And I'm going to go back to Andy's point just for a moment. Andy's point, Sean's, we always pitch that, these transactions are 90% disclosure and 10% paperwork. Trained monkeys can draft most of the paperwork properly. There's some guys here who still do some things a little bit different that they shouldn't do, but that's not for me to say one way or the other. But I think these transactions is all about disclosure. And as you said, Sean, you want to make sure that the seller and buyer are going in with their eyes wide open. Know what the issues are and the risk factors, and navigate it from there. Because when you have a willing seller, you have a willing buyer, you have full and complete disclosure. And I add a caveat, time to review the paperwork and or seek consultation of their choice. You got a good deal. But that's what you got to have. Trying to push a deal through in a day or whatever it might be, unless you're in an imminent foreclosure scenario, I just don't like seeing that kind of stuff. So I'm with you on that. And Andy, about paying liens, the key is you can buy a property subject to all of the liens that are out there if you wish to do so. I don't care what kind of lien it is. You just have to realize what it is, that it's there, and know how to deal with it appropriately. You know, for instance, a judgment lien here in Texas has a life of 10 years. An IRS lien has a life of 10 years, unless, of course, they renew and extend in some format by doing extending those in some, whatever the issue may be in accomplishing that. But it just never happens. You don't ever see it. I see it. I think I've seen the judgment lien renewed and extended once in my 30+ year career.
You literally live in a different world than I do. I've got one. I got one that got renewed every 7 years, like clockwork, since 1998.
Really?
We had to pay it off last year.
They pissed somebody off, didn't they?
Yeah.
Yeah, no,
Somebody was taking it personal.
Our liens are renewed more often than not. They hit the renewal up generally in year 6. They have a 7-year lifespan here for judgment liens, and they generally are renewing them in year 6, just to be on the safe side.
You know, in Texas, I'll just tell you, at least I don't see that stuff. You know, most of these are, you know, credit card liens and eviction, something, this or that, whatever it might be along the way. It's a rarity in my opinion, what I've seen. That's interesting hearing that about Georgia, at least.
And the tax liens get renewed too. Yeah, and they also get renewed. Not the IRS typically, you're right. Those typically fall off. But if you're dealing with like revenue liens, they get renewed as well. They file their they sent the sheriff out there to look for property, didn't find any. They hit their nulla bona and refile.
Wow. We just don't see that. You know, but at the same token, you know, I'm asked this question, I mean, gosh, weekly, daily, about liens and whatnot. We teach a little class on how to navigate liens, just to help them understand how the liens work. And some liens will stay on until maturity, like a mortgage lien. I had a deal pop up the other day where the note hadn't been paid on for 10 years, but the deed of trust still had another, I don't know, 8 or 10 years to run on its maturity date. So in Texas, that note becomes stale. You're not going to be able to collect on the notes, but the lien on the property is still valid, and you can still foreclose under the lien. You may not be able to seek a deficiency judgment if you ever wish to do that. And of course, so often than not, you know, it's not worth doing that because the person you're going to sue has no money anyway, and you move on in the line. And there's a time and place for all those kind of things, but I just want to make certain that when you pull your title search or your whatever that search is going to be, that if liens pop up, okay, Mr. Seller, Mr. Buyer, how y'all want to handle these? You want to pay them off? You're going to buy it subject to. If you understand how they work and don't work, like a child support lien is going to be on there and probably not fall off if there is one. And even though they don't attach to a homestead, title companies here want them removed. So you want to be able to deal with those kind of things. But to answer your question with specificity, Andy, from our perspective, all we want to do is make sure that all the liens are disclosed properly, that you understand what's out there and how they work, and then make the business decision on what it is you want to do.
Coming from more the title side of it, you're exactly right. I want them removed. I want them paid. We have a file right now that is supposed to close on Friday. They had a magistrate case. We became aware of the case, but there's no lien yet, no lis pendens, right? But we're at least aware that there's a judgment coming down the pike potentially. The judgment has been issued, but to our knowledge, the lien hasn't yet been filed. And I was just talking to one of my underwriters who's writing this, has some other quirks in it as well. And I said, look, I'm going to make her pay it at closing anyway, because I don't want to get caught in the gap where they file a judgment lien and I didn't take exception to it, you know, and obviously I insured over it and I get caught, you know, with a little bit of a loss. So she owes it. It's obvious she owes it. And I'm just going to make her pay it at closing.
All right. If you're just now joining us, this is the Creative Finance Collective. We're taking questions throughout the hour until we run out of them. So we have a few more questions we'll get to. Also, take a note. The barcode at the top of the screen takes you to the INREM Podcast YouTube page, which is the best place to really engage with this sort of content. Go there, subscribe, and post your questions. We'd be happy to get to them. We've got another question still along the same lines as the liens. Is it okay if they don't disclose a lien? I think that's asking if a party to the transaction fails to disclose a lien. How do you want to address that?
So
I mean, if
in Arizona, sellers, I'm assuming the seller would be the one that doesn't disclose the lien. Presumably it'd be picked up by title, but it doesn't really matter. A seller must disclose any fact that would impact the buyer's decision to purchase the property. That's the law. There is no as is in Arizona. That's the disclosure that a buyer or a seller has to go through. And so, when I have seller clients come to me and say, "Hey, can we waive disclosure? Can we waive, seller property disclosure statement? Can we waive inspection? Can we waive this? Can we waive that?" Say, we can put that in there, but I would advise against that. Because Arizona has no as is, and you have to disclose material facts, and a material fact is one that, could impact the buyer's decision to buy. So if having a lien out there against the property is going to impact the buyer's decision whether or not to buy, well, of course it is, right?
Yeah.
That has to be disclosed. So in my view, the seller has to disclose it. They have a legal duty to disclose it, and they have liability if they don't.
So I have a question on that. So obviously Georgia is a little bit more of a Wild West, it sounds like, than Texas with all these homestead protections, which we don't have here, and Arizona with this disclosure. So, and you're right, title picks up on it. And if it is in fact a lien as opposed to simply money being owed, right? There's a difference here. So I want to make a distinction that a lien, we're talking about something that has already attached to the property, either because it's been filed and perfected or because it's, kind of self-perfecting, such as our inchoate liens, right? Which we have a lot of here in Georgia. Um, but to your point on that, so if the lien is filed, so let's use your example here in Arizona. The lien is filed of record, which means legally everyone is presumed to have knowledge of this lien. But for whatever reason, our seller wasn't paying attention. Our seller is actually unaware, although they are legally aware, because again, it's been filed in the public records. For whatever reason, title has a miss. Whoever ran title wasn't paying attention. Could the buyer come back against the seller for failure to disclose something that they had legal knowledge of, although they lacked actual knowledge?
Yes, and the reason is actually, Drew, is because they contractually agreed via the warranty deed to convey title. That's a covenant of the warranty deed, right? Is that you warrant that you're conveying good title, subject to any exceptions, listed in the title policy. That's what you should have in your warranty deed, subject to exceptions and that type of thing, but you've warranted title. And so technically the seller is on the hook, even though they didn't know about it, although that claim would be a contractual claim as opposed to the seller actually having not constructive knowledge or notice, but actual knowledge of the lien. If they have actual knowledge of the lien and they don't disclose, and that's fraud, and that's a whole separate type of claim. But in my view, because of the warranty deed, they're warranting title to the property. And if there's a lien out there, then, they haven't provided good title and they've breached the warranty in that deed.
Right. So
And
the
by
way
the
it
way,
works here is a bit more convoluted. Generally, what would happen, and you're right, I mean, we have the same language in our deeds, and we also have to make a distinction between a lien that was caused by the seller and a lien that was caused by a previous owner in the chain. Because generally, our standard forms here, they only take via a special warranty deed
Right.
or a limited warranty deed or
Mhm.
whatever you want to call it.
Yep.
So generally, the seller is warranting they didn't screw up title. Although if you're giving a general warranty deed, obviously it protects the entire chain. But in
Correct.
our case, if there is an issue, the buyer obviously bought title insurance. They would file a claim. Then obviously they would come back to us. We would say, well, here's our owner's affidavit, right? The owner swore that they had no knowledge of this, right? And then you would bring out, depending on if the lien was caused by them or caused by a previous owner, right? You would then have to assess whether or not you had the proper kind of deed. So it's a bit more complicated here, probably easier from the buyer's perspective, because again, they're just going to file an insurance claim because that is absolutely covered
Right.
by their title insurance. So they wouldn't
And,
have to go
and that's
directly against the seller.
right.
Yeah.
And that's Arizona as well. Although, and I'm sure this will happen in Georgia as well. What does the title company do? They subrogate, right? So, and then they will look to the seller and be like, we're paying your $30,000 judgment that was recorded that we didn't pick up on and that you should have, that you warranted
Yep.
it against. So, how much of that 30 are you going to write it, pay us back for?
Yeah,
No,
knock on wood, I haven't had that yet.
yeah. So by the way, I agree with all that. When you execute a warranty deed, whether it's special or general, you're warranting the title for at least the length of time that you owned it. And then if a lien attached to the property or, and you didn't know about it. And guys, man, I find all the time people, judgment liens pop up, this pops up. Usually it comes up on title in that regard. So you can deal with it then. But could something come up that they don't know about that is out there that isn't picked up by title? The answer is yes. And I think the answer is exactly what you said, Sean. You're warranting title in the title company, although they're going to be on the hook if that lien was not picked up on their title work. And you know what? I'm sure it's all of your experiences. It happens more often than we want to admit to, but the underwriters, the things, sometimes it just happens and it's okay. And then the underwriter winds up having to deal with it in some fashion out there. But, I rarely see somebody who just blatantly knows something is out there and fails to say it. It happens occasionally, but so often that it's just an unsophisticated situation where they don't know what they don't know. But typically, your title report is going to pull those kind of things up for you.
And the case that I've seen it most often, oddly enough, crazily enough, is HOA liens. Somebody buys a townhome or a property in HOA for an investment. They never take owner occupancy, and we get to closing, and obviously we order the HOA, letter. We see in the record it's part of an HOA of some sort. We reach out and order the closing letter, and the seller swears in their intake sheet they're not part of an HOA. I mean, this is a fairly common issue. Is seller swears there's no HOA. Obviously, the records indicate otherwise, and then when we reach out, lo and behold, there is in fact a functioning HOA, and all of a sudden they're staring at a $20,000-$30,000 HOA bill, and they get hopping mad about it, right? Because there's not an HOA. No one ever contacted me. Well, I hate to break it to you. You're in an HOA and you haven't paid them for the last 2 years you've owned this thing. So either pay it and sell and get, whatever net proceeds are, or go sue your HOA and we'll see you when you paid them anyway. So that's where it most often comes up for me. And I don't know whether they're lying or not. I just know that that's the most common source of the issue, is the failure to disclose an HOA.
Yeah. If you're just now joining us, this is the Creative Finance Collective. We're taking questions through the hour. We got a few more to get to, so make sure that you post them. Also, there's a barcode at the top of the screen. Feel free to scan that. That'll take you right to our YouTube page, the best place to interact with our content. Go ahead and subscribe. We'd appreciate it. Have another question going to the subto transaction. Can you fix a failure to disclose prior to the close of escrow? I think what this is asking is if you're not using the perfect purchase contract forms that have already built in the subject to addendum that we've discussed on multiple shows. I've just entered into the transaction. I didn't have that form purchase contract. I'm watching the collective now, and I realize, boy, I think I need to disclose that. What can I do to fix that if escrow hasn't closed?
Disclose.
Just disclose.
Is that the common answer?
Yeah. I mean, so like on our self-perform closings, we have like a buyer acknowledgement and disclosure that we send out that we want for our protection anyway, which has a lot of those disclosures already baked in as well. So it's the same thing. Just, say, hey, buyer, hey, seller, here's a disclosure. You mind initialing or whatnot, and, make that disclosure.
So if it's not done as part of the purchase contract, it can still be cured. You can still establish disclosure to the parties before it closes.
Yeah.
And you
It
should.
depends on what it is. Yeah, because here in Georgia, I mean, obviously, if you're using the GAR forms, you have to disclose the HOA and you have to disclose the amount of the payments, right? And you can redisclose later. This is an interesting take on it. You can redisclose later, right? Let's say that you order the closing letter and it turns out the initiation fee is higher than you put in your HOA disclosure. I'm just using that as an example. You as the seller are now on the hook for whatever that difference is. So if you estimated $1,000, but it came back as 1,500, because you disclosed 1,000, obviously the buyer agreed at the initial PSA that they were responsible for the 1,000. If it turns out later the closing letter comes back and it shows an initiation fee of 1,500, the seller is actually obligated to do that. Now, of course, you can always amend and do whatever you like, but I just wanted to point out that just because you disclose it doesn't necessarily cure it, right?
Right. All right. We've got another question here. Can you get a HELOC on a property you're taking over sub 2 with the HELOC in the new buyer's name and the new sub 2 loan still in place? Let me know if you
Well,
need me to read that again. Go
no,
ahead,
I got
Scott.
it. I'm going to answer the question from a mortgage perspective. It depends on who the lender is.
Right.
So long as you own the property and are the deed record owner, that lender doesn't necessarily care who the first lender is. They're going to be in a second lien position anyway. And it's going to be a credit driven loan, most likely. It's going to be recognizing that they're going to be in second lien position. And there are probably lenders who would do that out there.
Mhm.
But that's going to be a lender by lender question that there's not a direct answer to.
Right. So legally, can you do it? Yes. Logistically, can you do it? It depends on the lender.
Is that a strong, definite maybe?
Strong, definite, maybe.
Strong as a maybe can get.
So the answer is yes. It just depends on who your lender is.
Right.
Oh, wow.
Can we
If
say
only-
that any other ways?
If only we could get this kind of consensus within our culture, we'd be all in a good place.
Yeah.
All right, so we've got another real specific question here. How do you handle any checks that come from the bank after you acquire sub 2? Bank said the POA isn't enough to deposit. They suggested opening an account with the seller's name or have them cash it.
Want me to answer that question?
Yes.
Sure.
Because, I hear that constantly. And my answer is guys, endorse the back of the check and just deposit it. I will tell you, 30 years of doing the business, never had an issue. So what is somebody doing? Are they going in and trying to cash the check? And then the teller pulls it over, goes, well, I need to see your POA, this and that. And all of a sudden you get all these issues because they haven't got a clue what they're talking about half the time. And they just don't want to deal with the POA issue, even though if you've got, like in Texas, we use a very specific power of attorney that's state promulgated that gives you the direct ability to work for any banking transactions, insurance transactions, and things of that nature. So of course, you always want to know what type of a POA do you have? And I see some pretty rinky-dink POAs out there that get disseminated. But historically, for me and my offices, we get a lot of those checks that come in. We just endorse it, do a straight deposit, and literally have never had an issue. I just think that when you start bringing the human element into it, things happen.
It doesn't hurt to deposit it through an ATM either.
Can you, by the way, I don't have an ATM card. Can you actually do that?
Yeah, you can deposit through an ATM and, it's not like it's a different person that's reviewing those deposits, not even a teller. So you put it through an ATM and you probably potentially have a better chance of, them not, creating an issue or whatnot.
I think that is probably, so those are the best answers I think you can have right there. And I'd like the ATM issue. Never heard that before.
Well, it removes the human element, or at least on the front end, it removes the
Mhm.
human element and then forces the folks on the back end to be like, well, do I want to make an issue out of it? Aren't you forced to, probably when they're dealing with on the back end, they're forced to do the due diligence they need to Otherwise, they have to like the process of unwinding what's been done versus just being able to tell somebody, I don't know what the heck this is at a teller line is a lot
Right.
harder for them.
Yeah, a teller can just reject it, but if you deposit it through the ATM is going to take it. And then now they got to do a letter to you. They have to reverse the transaction. They have to do all of this work to undo it. Or they look at it and they're like, yeah, it's $1,000, whatever,
And if it clears the
type of
lenders, the issuer's bank, what do they care?
Yeah.
They don't.
Well, see, the difference is it's like the burden of proof. Each one of these forces to do it through the ATM forces the bank. The bank's now in a position of finding reasons to accept it, versus on the teller side, they're finding reasons to reject it. And I think that it's an incentive based kind of thing. All right, let's see, we have another question. When purchasing a sub 2 with an HOA that has rental restrictions, is there anything can be done about that? Well, I think this is probably has to do with somebody who wants to use it for rental purposes, right? The rental restrictions aren't by themselves going to do anything to the sub 2 transaction, right? It's what you want to use it for. And
Well, so I'll answer it according to Arizona law. So you have to make sure that the rental restrictions are actually in the CC&Rs. So we've had and we continue to have HOAs who, boards operate through fiat, and they basically say, we don't want rentals in here, so we're not going to have rentals. And they pass some resolution of the board and say, oh, you don't get to rent your property in here going forward. And they pass that, and that they claim that's an official HOA action, and it's not. It's not binding. It's not enforceable. You don't have to follow it. And, those restrictions aren't valid. It has to actually be in the CC&R. So just because you think that you have regulations because they're telling you this, the board's telling you this, the board has published a policy, the board has published, architectural guidelines that have that in there. They've published other things that are restricting rentals. Those are all not valid. The only thing that would be valid is if there's a restriction within the CC&Rs, validly passed CC&Rs, validly enacted CC&Rs that are of record. Then yes, you're restricted as far as the rental of the property. And you're going to have to figure out what you want to do with that property at that point, as far as, its use and that type of thing.
And be careful on the flip side as well. I have had one where it's not subject to, but it's a rental restriction. It's written into the DCRs. But the HOA was real amenable, and they passed a resolution that they were going to waive the DCR requirement, capping the number of rentals at 30%, and they had already hit their cap. That was in their closing letter. And of course, the lender wanted me to, ensure this wasn't going to be an issue. And obviously, it's in the DCRs. And to Sean's point on the reverse side, just because the board says, hey, I'm going to ignore my rules, doesn't mean they actually can ignore their rules, because any other homeowner could obviously start some kind of lawsuit and then force the action. So it can run the other way too. So just be careful of that. Don't trust an HOA to tell you, look at what their docs say. Always follow the actual filed DCRs, or in Georgia, there's another twist, even the plat, because sometimes when they are approving the subdivision and the plat, the city will actually have a restriction on the percentage of rentals.
Yeah, you can do that. And, for the investor who's buying that property, the key, I think we all agree with, is do your homework in advance.
Right.
Ask the questions, get a copy of the rules and regulations and the condominium regime, look at them, read them, go to that specific point. If you can't find it, have somebody do it for you. Get it in writing from the board in that format and some clarification basis. Have a good friend here in Dallas area who is still, after 2.5+ years, fighting that with his HOA. And he is pretty much 100% in the right, but he's still fighting it through multiple court appearances and battles and whatnot, which means legal fees. He's doing a lot of it pro se and whatnot, but oh my gosh, what a headache.
Mm.
And the question is it worth fighting for it that much or not?
We have another question. This one is a Texas specific question, so we'll let this go to Scott. But there's a property that was foreclosed by the lender in Texas for some reason, or for some reason they're selling it via quitclaim deed. If I buy it, could I sell it with a warranty deed?
Oh, so does that explain it well enough?
Yeah, that's your answer. That's not. Yeah.
What I find interesting, guys, is historically, Texas does not recognize a quitclaim deed. They say if you can get a quitclaim deed, you can get a special warranty deed. Now, you might have an loyalty deed or something like that in the event of a divorce, or it might be they might execute a deed without warranty for some particular purpose along the way. They just don't like quitclaim deeds. I've run across a situation where a person who owns a property, they've owned it for 8 or 10 years, and maybe a prior relative gave them a quitclaim deed, way back then. Well, the bottom line is, I have to go to the underwriters and explain, hey guys, the statute of limitations have run for anybody to come back and claim that they weren't conveying away whatever interest they had with that quitclaim deed. And they'll usually accept it, but there's a certain time frame they want to see out there along the way. Back in 2022 here in Texas, they passed a new law saying if a quitclaim deed is executed on or after January the 1st of 2022, and provided it's been recorded for at least 4 years, then it will be recognized as a conveyance of title at that time. Of course, going back to the old conversation we had a minute ago with Sean and whatnot is there any warranting the title or not? Or is it is what it is? You get whatever their interest they have, subject to whatever might be out there. But that kind of falls in line with the statute of limitations issues again. That same 4 years running is the statute of limitations. So they just codified it, made it easy, and said, we'll accept them if this is the situation.
So in Arizona,
to answer his question specifically, the answer is if you get title by a quitclaim deed, you really don't have title until at least 4 years down the line.
well, let me ask you this. So in Arizona, we have those very similar issues, but we've been able to overcome them with going back to the grantor and having them sign an affidavit with whatever magic language the underwriter wants, saying, yeah, I executed it. Yeah, I believed I had title. Yeah, blah, 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 blah. And, we basically get them to give us some type of affidavit that meets the underwriter's requirements. And then they're okay with us going forward and allowing it to be conveyed out by warranty deed, and they'll insure it going forward. Is that something that's doable in Texas?
Say that one more time for me, please.
So basically, we've had situations where there's been quitclaim deeds of record and our clients want to sell them. And of course, we have the same issue. We go open escrow. Underwriters like, oh, I don't like quitclaim deeds. We're not comfortable with this. And so then we've gone and said, okay, what do you need to make yourself comfortable? And they say, well, we need an affidavit from the grantor under the quitclaim deed, basically saying that's my signature, that yes, I had title. Yes, I had this, I had that, and whatever magic language the underwriter wants. And we go then to the grantor and we say, hey, title wants an affidavit because they want to feel, better about your quitclaim deed and your ability to convey title. And will you sign it? And if we can get the grantor under the quitclaim deed to sign this magic affidavit and deliver it to title, of course, notarized and the whole thing, then title feels better and will warrant it going forward.
Yeah. So
Just want to
I
throw
have
in
not,
Georgia has no issue with quitclaim deeds.
yeah, in Texas at all, by the way. I would tell you if you can get an affidavit executed in that regard, then most likely you can get either a deed without warranty or a special warranty deed just as easy.
Mm.
I think they're going to want to see that here in Texas at least.
Hmm.
Has been my experience.
So can y'all explain what is a deed? What is the difference between a deed without warranty, where they're not claiming they own it, and a quitclaim deed where they're also claiming? Because again, to us in Georgia,
Mhm.
quitclaims are a normal part of existence. We don't care for them, but at the same time, they are perfectly valid as a form of conveyance. It's just you take it subject to whatever's out there, and you take it subject to whatever their interest was at the time they made it, which is why we have the after acquired title doctrine is effective as to warranted and limited warranty deeds, but is not effective as to quitclaim deeds. So what is the difference between a deed without warranty and a quitclaim deed? Because we
Well,
don't have
it's
that
not
distinction.
in my vast real estate knowledge as the real estate expert here, yeah, whatever. The quitclaim deed, from what I understand, says I'm giving you whatever possible ownership I may have, but I'm not even tell you I have had ownership. Whatever it is I have, I'm giving to you. They're just not saying what they have. A deed without warranty at least says, hey guys, yeah, I own the property, but I'm not going to warrant that there might be something out there I'm unaware of. Here it is. And so it's the next step up is the best way I could describe it from a quitclaim deed. It's not what I would like to see, but it does work. It says at least it affirms that the guy owns the property. With a
Wouldn't
quitclaim
that be a
deed,
warranty? Right. If
yes.
I say I own something, aren't I making an affirmative statement with respect to title that I own it? Wouldn't that be the same thing as a war? That's what I'm saying. Georgia doesn't have this. So to us, it's just a step from nothing at all to a limited warranty up to general. We only have three ways to do it.
Yeah, I just think, as I said, the quitclaim deed says if I have any interest in the property, here it is. But the warranty deed, the deed without warranty says I have an interest in this property. I actually own it in some format. I'm just not going to warrant title or that there couldn't be a possible defect along the way. And, from there, it is what it is.
Got it.
We've got time for one final question, I think. We do have another question. Have any of you guys taken out a HELOC after you've taken a property subto? I have not. Anybody else? Scott, you do a real estate investor. You ever run into that?
Well, I would never go to a bank to borrow money. I'd go through private capital sourcing is what we do in those scenarios. I think banks are going to, pretty much shy away unless you're a really good customer of theirs and have really good deposits.
Yeah. Yeah. As discussed in a prior question, it obviously can be done depending on the bank, but doesn't look like any of us have ever done it personally. Well, good stuff, guys. We're at an hour. Lots of questions. Good discussion. And appreciate your time. And let's get together and do it again next week.
Adios, boys. We'll see at least two of y'all next week, I think.
Oh yeah, you're going to be in town. You're going to be in Arizona for the collective, right?
I'm just waiting for the whining and the dining.
Wow,
I understand the getting tired of you response that started this thing off.
Yes. Yeah. All right,
And
gentlemen.
I will tell you, Sean and Andy, I think my partner across the room is talking to me here about our lunch and learn on Tuesday.
Tuesday from 12 to 1:30 in the conference room on the lower
From
floor.
12 to 1:30.
All right,
At y'all's
guys.